Thank you for joining us. Here we are again, Homeowners for Justice. Our thanks goes out to Michelle for letting us use her song as a lead-in piece. It is up to us to make a change, and we can do this. And I apologize that I messed up. So that's why we're starting a few minutes late. So no problem. If you're going to watch this archive, who cares? So today, real quickly, we're planning, I really want to hit the highlights on several different topics. The government settlements, how they are a scam, and how the homeowners probably will see very little money in it, cash. And then I also want to talk, I've got Valerie Lopez on the phone with me right now. She's going to share a little bit of what I would call boots on the ground for what we discussed yesterday, the tangible and the intangible concepts. This is why it's so confusing. One of the reasons that it's so confusing, the MERS and the forgery and the fraud that's required to foreclose. And we just started this discussion yesterday with James about how what the banks have done is taken tangible property and converted it into intangible property. And is going to explain to us how that rubber meets the road if you're in court, and how we might be able to use this to help either postpone auctions, rescind notices of defaults, maybe even possibly get the homes in a quiet title action, get the homes back under ownership. So we want to discuss that briefly, and this just came up last night. So she and I have already discussed that we'll probably be doing a real better presentation with documents next week. Then I really wanted to take a few minutes and expose SB 900. I'm not an attorney, but I want people to hear it read out loud, and I'm going to show, I've highlighted sections of it so that everyone becomes more aware of what that law that just took effect this January 1st for California, what that law will really mean. Quickly, I want to explain who is getting these homes. If you're losing your home, who's gonna own it next? I want to bring that to your attention. And then the fact that also there's some significant things going on in other states, like Florida has shut down 2 foreclosure mills. And what can we do here in California or other states to shut down the foreclosure mills in those states? Because if they can't issue a notice of default, then they can't foreclose. And that is one of the points we want to take advantage of. So quickly, some announcements. The LA Occupy had their rally yesterday. They have issued a writing. I want to share what they've said on that because it is truly powerful. It is very much a fraud scam, and they are very upset about it. And so we want to bring that to our attention. Also, I want to mention that there's going to be a foreclosure defense workshop next Tuesday. Linda's going to present what kind of information we need to get, how we get it, what we can do with that, how we might be able to stop our auctions, our notices defaults, gets those rescinded, and possibly get set up for keeping the house. Wouldn't that be nice? I mean, that is the whole point. Here is the Occupy Fights Foreclosure, and I just want to read portions of this. They're very upset, and they are joining the voices of millions of homeowners in saying this is corruption and injustice cannot and will not stand. Insiders have called the so-called independent foreclosure review a sham of a project. Banks insisted, now get this, banks insisted that no TV, radio, or print media be used to explain the program and its availability to former homeowners. And of course, these homeowners were displaced, so when you sent mail to them, they're not going to get it. That's part of the problem. That's kept the people in the dark, even though this was mandated by the courts. Only 11% of the eligible homeowners had come forward as of December 31st last year, and most homeowners have seen no restitution, even though the independent contractors that did the reviews were working under the banks. Whatever they found was quality controlled by the banks who'd violated the laws, And the claims reviewer, and they name him, described in detail on Naked Capitalism. And I want to tell you that that article is linked to Homeowners for Justice webpage, Stealing Our Home. So you can go find that real easily. They routinely found a dozen or more violations of foreclosure laws in a single file. This is not any surprise. We've had the independent audits telling us the same thing, not to mention all of the other issues like immorality, incompetence, poor judgment. But banks routinely simply erase the violations as the list of harm on borrowers grew. And so the banks told the reviewers to ignore them. This is criminal behavior. And let's not ever forget, in Iceland, they have put these banksters in prison. That is the point. They've locked them up because it is criminal behavior. And we, the people, must rise up and insist that our agencies, here we go, the OCC, the Federal Reserve, Department of Justice, even the attorneys general, they're settling instead of putting these banksters in 3 hots and a cot. This is the point. And any victim of any crime doesn't have any peace until they know at least, number one, the perpetrators have been brought to justice. And then I'm saying, and the rest of the country is saying too, these people need restitution. They need their houses back. That's why I want to talk to you specifically about where are these houses going. Another thing, real quickly on these announcements, Oregon MERS. The Oregon Supreme Court did their MERS appeal. They had arguments. I live streamed that. You can check it out under my live stream channel on livestream.com, and you can listen to that. It's fascinating to hear the attorneys make their presentations, to hear the justices ask questions. And if you're like me, you'll end up with the feeling that, okay, these people are still confused. And this is why we've got people like Valerie on the show today. So Valerie, thank you for joining us. You were talking, can you explain to me what you wrote in the email to me about the tangible, intangible charts that we had on yesterday's show from James?
Oh, sure. Actually, CJ, I actually just emailed you a diagram, which might help a little bit. I don't know if it's too late to open it. If it is, that's okay. I'll just try to be as descriptive as possible.
I've got it. It's on the show.
Okay, got it. Okay, well, let me just go ahead and see if I can just go from the very beginning, and I'll make it just quick, and then I'll get to the highlight. First of all, as you already know, there's the tangible paper we can feel. We have the note, we have the security instrument, and essentially the original lender was the holder in due course. We know that. Okay, it doesn't really matter where the money came from. So what happened then is they ripped the value from the paper note.
Okay, what do you mean by that? How did they rip the value of the paper note?
Well, they pretty much they take the value from the paper note and they digitize it. It's the only way that they can send it to Wall Street.
Okay,
so it's kind of like in a disk form. That's the best way I can describe it. But essentially, that paper note is worthless. Okay, once they go ahead and digitize the intangible obligation of that paper note.
Okay, that would be what we would term a payment stream, right?
That's correct, the intangible payment stream, yes. So essentially, as James explained yesterday, that paper note is now void of any value.
Now, he said yesterday, and we've heard it from others, that they actually physically destroyed these notes. And I've actually heard somewhere along this last year's worth of research that it violated New York securities laws to have the actual note itself, the one that we're talking about, the tangible note that, people signed, to have that in existence with the securitization of the payment streams. And I don't know if that's accurate or not, but that's what I'd heard, and that was why they had destroyed them.
Well, that's correct. But again, we were supposed to all be ignorant to their design. Essentially, what many of them did, including Wells Fargo, is they kept the worthless pieces of paper in a vault or with the custodian, okay, thinking that let's go ahead and have MERS at least track it as far as who's holding the paper document so that we can go into court and wave the paper in the air and go ahead and smoke and mirror people to show them that because we're holding this worthless piece of paper, and they're never not going to know, they're all so ignorant, they're not going to know it.
Right.
So let's go ahead and just keep that just in case we need it. And that's what happened to me. But so essentially, you're right. You can't have securities and then a valuable note. You just can't. I mean, essentially, that valuable portion of the intangible income streams were actually sold to the individuals that bought the certificates. I hope I'm
okay. Okay, and the people that bought the certificates are our pension funds in Iceland, and they bought securities on Wall Street, mortgage-backed securities.
That's correct. Yes. So again, if you're looking at the diagram that we have here,
yes,
we have the tangible mortgage world. Again, that's how we always used to do business, whereby we would, sell a note, record an assignment, a deed of trust.
Right.
Sell a note, record it. That's just your standard local rules of jurisdiction, real property law, and that's what should have happened.
And that would have taken.
So essentially, what they did is they went ahead and digitized the income streams, sold it over to Wall Street. Now we're in the intangible world here. Of digits, etc. And it's okay that they did that. That's allowed by law. And again, what we should do is just line up all the laws here, but that's 15 U.S.C. 7001. But someone very smart who was actually formulating all these e-sign and UETA laws said, you know what? We have to make an amendment. Let's go ahead and create 15 USC 7003 because there's a lot of Gordon geckos out there. And can you imagine what would happen if they formulated all these electronic mortgage notes and deeds of trust? They could take that electronic document and sell it multiple times. So let's outlaw and say you cannot convert an electronic note or an electronic deed of trust and submit it over to Wall Street, and showing it as a representation to investors that this represents that your investment into these income streams is secured by a deed of trust. So when they, being the banksters, did this, essentially what they did is they actually broke this federal law. And that was where the commencement of the securities fraud commenced.
Okay, now, I'm sorry. Say that again in summary. Basically, who passed this amendment, the New York securities law?
No.
Where did this come from?
The 15, the e-sign laws as well as the UETA. I used to know it off the top of my head.
That's
about
okay.
2 months ago. I'm just realizing that I'm having a brain fog. But there were
That's okay.
some government agencies at the federal level that actually formulated the e-sign law,
okay,
as well as the UETA laws.
And we can document this next week when we really when you put this together.
Anyway, just know that it was a government agency that
Okay.
formulated the e-sign as well as the UETA, which allowed all of this electronic creation in order to do the securities, the selling of the securities. But essentially, again, I guess the most important thing is that it was okay to go ahead and sell the income streams, but they were not allowed to convert the written negotiable instruments on the tangible side. They were not able to convert those into electronic documents and then tell the investors that, hey, you know what, everything is kosher. We've got everything here. We have an electronic deed of trust assuring you that this is actually secured.
Okay.
And, we can go ahead and foreclose and take the home.
Okay, so what I hear you saying is that the government put in place a law saying you can sell the payment streams, but you can't electronically convert the deeds of trust that secure that note.
Correct.
Note to the property. Okay, so this would substantiate when I hear people saying they split the note off of the deed of trust. The deed of trust still sits on the property, but it's not securing anything anymore because the note, they sent that over someplace else.
Exactly. They actually sold the valuable part, the gold. They took that gold and they sent it over to Wall Street and sold it. Correct. I mean, they used it as collateral in order to go ahead and obtain the funds from these various investors.
And like James,
what they did, I mean, essentially that's why the investors were, livid when they found out, oh my gosh, you mean to tell me that you broke federal laws and that I wasn't really secured by anything but an unlawful document, a deed of trust? So that was the commencement of why all these investors went to go ahead and sue these aggregators, whatever, the individuals that were kind of
the banksters that put it together.
Banksters, yeah, they kind of put the scheme together, right?
And so is this? I mean, I'm thinking back. I've heard that when the investors discovered that there wasn't the collateral they thought there was in these mortgage-backed securities, that's when they started to withdraw their money. They had a run on this shadow banking system, and that's what broke Lehman Brothers and these other investment banks.
Right, yes.
In 2008.
The partial effect of the truth that when it eventually came out.
Right. So in 2008, we've got the investors figuring this out, but in the meantime, the banks just keep taking the houses.
Right. I mean, essentially, it's only because we allow them to do that. And that's why it's so important for us to all just really understand. And, if we don't understand it, well, then we got to make it a goal to make sure that we understand exactly why this is completely illegal and how to be able to go ahead and explain it to a judge, because it's beyond as far as incomprehensible as far as how we're not being able to get the justice in court because we're lacking the ability to be able to educate the judges.
Well, and the other issue is, because I've heard everybody is basically saying the same thing all over the country, and that is the judges aren't following actual law. For example, a notice of default is filed on a property, I mentioned this yesterday, that is filed by some entity that has no authority to do so from the recordings, and later gives themselves authority, or like one of the trustee substitutions that we saw talking with Linda earlier this week, Index, as attorney in fact for Wells Fargo, blah, 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 gives themselves, Index, the authority to be the new trustee. Which,
and then what are they actually assigning anyway? What are they assigning? In the case that they're trying to assign the electronic deed of trust back over to the real property law jurisdiction, well, 15 U.S.C. 7003 says, sorry, Charlie, you know what? If you chose to break the law, then you can no longer try to attach that deed of trust and try to get it to be applied towards the UCC laws. End of story. You can't do it. You chose to break the law by converting it into an electronic document and smoke and mirror all these investors by taking their money. And unwillingly and unknowingly, all of us homeowners were involved in securities fraud as well.
Well, why can't we make that happen?
We can.
What is we? Because individuals are going into court and they're not being able to make this happen, are they?
Right, and it's only because of the fact that, again, I just really believe that attorneys, they're just, some attorneys, not all of them, but they're just not, maybe they have attention deficit disorder. They're just so busy that they really can't hone in on what James McGuire is trying to point out according to law. I don't know. I think we have to work harder in trying to make sure that we find attorneys that are willing to go ahead and stand up a bit against the big boys club.
Oh my goodness.
And understand it.
Okay, so first off, I'm hearing you say it's too complicated, and the attorneys either don't have time or enough interest in trying to figure it out. And see, I've talked to attorneys that view themselves as good attorneys. They're not going to rip off their clients. They're going to do what they feel is right. They go into court under actions, or they're saying things to like they actually said, well, I don't want to support any owners that want to do any quiet title, who owns the note, and he starts naming these types of pleadings that don't work in California. And I find that really distressing, because they should be working if the judges were ruling according to the laws that we've got on the books. Just like, go ahead.
Well, I mean, in my opinion, I don't know, I just kind of feel like I'm kind of like James as well, in that it's, I remember the childhood story about the Emperor Has New Clothes. It's like, you can't ignore it. I mean, how can you cannot ignore it. I mean, a dog is a dog. It is what it is. And I don't think it is that complex, really. I think that I know that you and I and anyone else, I'm sure that we're going to be able to simplify it, because we have that ability to go ahead and take a complex. And as James stated yesterday, that's what they wanted to do, is they wanted to make it so complex that no one could figure it out. But it can be figured out. Other judges, other law professors have been able to catch on to what James has disclosed here, and it's all in the law.
Right.
And we can do it.
And truly, I really appreciate you coming on and talking about this again in slightly different ways. Now, before we end this conversation, though, I definitely want you to mention those two items. You said I think one was a Bailey's letter and the other is the MERS something.
Yes. Okay.
So explain that.
Talk about that. What I was trying to explain to you is just pretty much to support James, what he was saying concerning the fact that the intangible income streams were given to your investors, right? They were assigned to some trusts, etc. Now, the MERS, what's called a MERS milestone, the entire function of the MERS milestone, it has two jobs. One is to designate who is receiving those income streams. That's the first job.
The
second job is also to keep track as far as who's holding those, phony baloney documents that have been tampered with in the paper world. The note, which actually has zero value, as we know.
Okay, now, just before we go on, how do we get the MERS milestones?
Well, you know what, I would say that is just a matter of luck. Some people have been very successful in just playing dumb and calling their lender, their servicer, and asking for it, and just happen to be very lucky to get a clerk that will just send it right on over to them. And many other people are just having a very difficult time. You would have to subpoena for it more than likely, because the lenders don't want you to see it.
Now, here's a question. Can a person get a subpoena without being in court? Do you know?
I don't know, but I'll let you know, just because I'm actually working on something. I need a subpoena for one of the endorsers on that paper note, so I'll let you know.
Okay, so basically, some people are just sending a letter to the servicer and saying, send me the MERS milestones, and they're getting them.
Right. I wouldn't send a letter. I would just call up and just hope to see whether or not maybe you might be able to get some clerk that is just completely oblivious.
And send them to you accidentally. Oh my goodness. And then on these MERS milestones, how accurate are they?
They're pretty accurate. They're very accurate.
And this should be basically a history, if you will, of the transfers.
Right. It'll just show who's actually receiving the intangible income streams.
Okay, so that's over here under the, we're going back to your little diagram, which is still up on the screen, and that goes back to the payment stream, and it follows the intangible obligation. So whoever is getting it, that's what the MERS milestones should show? That's
correct. Now, yes, so what's very interesting is that if you look at the tangible mortgage side,
yes.
especially prior to all the securitization issues, et cetera, the hiding behind the curtain of MERS, we had what's called a Bailey's letter. So every single time a note was sold to another party, they had what's called a Bailey's letter, who showed who was the next owner of the note and who was assigned the deed of trust, which went along with it. So if you were to compare the Bailey's letters and the endorsements of the note, guess what? They're not going to match.
Of course not, because they've actually stripped the payment stream off, and they're tracking that over in MERS, over here on the intangible side. And then on the tangible, shouldn't that Bailey's letter show, shouldn't they also have to record an assignment?
Absolutely. That's what the law says, right? In California, I know that it specifically says that for every sale of a note, we have to be notified within a 30-day period. That's actually a federal law. Let's see here. Well, anyway, I'll go ahead. I know it's 15 U.S.C. Chapter 41. Anyway, I'll go ahead and make sure that we get this all over to you and we can dissect it. But
yes,
there's definitely laws in the California real property laws that state specifically, that's the Article 3 world, remember, that we talked about yesterday, that these
right.
assignments definitely need to take place. But again, what these banksters do and their attorneys is, again, they try to play on our ignorance and say, oh, no, we don't have to do it. Well, of course, they don't have to do it under Article 9.
Over here.
But the bottom
right.
line is that they're
right.
trying to smoke and mirror us by avoiding the actual assignments. And, I mean, they can, because they pretty much have made a massive mess of this entire situation at this point.
And because, and I've been saying this, and because, again, I'm not aware of all the legal details like we're bringing out right now in the discussion, but in general, they did not have the authority to foreclose. That's why they forged all the documents. And so right. they're trying to catch up the intangible, if you will, the intangible side with the tangible side. And so right. when the payment stream stops, now the like we showed in the chart yesterday, one of the charts, when that payment stream stops, the insurance pays. So that's AIG, a credit default swap, or Fannie or Freddie, and that's paying the investor over here on the intangible side.
Exactly, yes. So the investor is paid off, and you also mentioned about the mortgage default insurance also.
Right.
I believe it's after 60 days the banks
yes.
Apply for the mortgage default insurance. And
right.
I know that one of the requirements is, guess what, no fraud can be involved. Well, guess what they're doing?
It's
they're
all fraud.
Pretty much raking the taxpayers by filing all these claims, and I would say there definitely is some securities fraud involved in this transaction.
I would, and insurance fraud all over the place. In my book, they've just defrauded everybody. They defrauded the IRS because these are not the pass-through investments they said they were, and long-term. Obviously, they've defrauded the laws on the tangible side by forging all the foreclosures and assignments and trustee substitutions. Now, on the intangible side, I've heard it, and I don't have independent proof. Maybe you've heard this or know about it, and that is that they've sold these payment streams repeatedly. So the payment streams for a loan or a bunch of loans shows up in several different mortgage-backed securities.
Well, yeah, I'm not really sure exactly what they may have done, but yeah. I recently received a picture of the trust. I have a Freddie Mac loan, one of my rental properties, and I've been requesting for Wells Fargo and Pike Duncan to release the name of the true creditor, and of course they have refused. But it appears that there's like multiple classes within this trust. But anything is possible. I have a set number of different classes within this trust. But, again, as I told you, Gordon Gekko probably could be in the seat at Wall Street. And if you were Gordon Gekko and if you had this electronic note and deed of trust, would you be tempted to sell it to other parties that they didn't know and they never had to have that instrument delivered to them? Well,
exactly.
So that's possible. It may have happened, but I can't really tell you, for every situation that it happened, because there's only so many Gordon Geckos in the world, right?
Well, I so appreciate you sharing with us today, and I'm looking forward. Could we do this next Wednesday? Could you?
Sure. Okay. And then what I'll do is I'll send over to you some documentation, and you can go ahead and review it, because it's going to have all the laws and all, and explain things a lot more thorough.
Perfect.
And then hopefully we can just go ahead and put it together, and I'll help you if you'd like also. And that way people have the laws, and then hopefully we can just go ahead and work together and just, taking these attorneys and just saying, you must help us go ahead and take these judges and enforce them to enforce the law.
One of there have been several ideas that have already just come to the surface. People all over the country sharing with me their thoughts and support. And one of the ideas that is now turning up to be hot on our plate is for Homeowners for Justice to start petitioning for grants from large charitable funds to get enough money to hire enough people to help anyone and everyone in the country that needs help to stop their foreclosure, to do this for free. And using these laws, definitely we can hire attorneys that really will represent the people and help them either go into court pro per, or we'll be able to file some kind of class action, whatever it is, to get injunctions to stop these foreclosures, shut down the foreclosure mills. We just have to rise up and help everyone. This has been one of my major thrust, because it doesn't really matter whether you're very rich or very poor. Everyone's getting cheated. The very rich are losing thousands, hundreds of thousands of dollars. They're paying attorneys and getting nothing in return, just like the poor people who are paying attorneys and getting cheated. And or the attorneys go into court, don't know how to argue the case, don't know how to present the pleading, and so they don't get the results that we need. So I really appreciate whatever help you can be. And
no problem. I'll go ahead and scan it over, and it'll be in your email.
That's great. Thank you so much, Valerie. I really appreciate your participation today. And before we leave, viewers, I would like to really bring to your attention some of the articles on the Stealing Our Homes page. I'm just going to click through them here so that you're aware they're there. This 10 banks agree to pay 8.5B for foreclosure abuse. This states that advocates estimate, only my word, about 400,000 homeowners would be eligible. Give me a break. There have been 4 million foreclosures, and we already know from a report like the Equitas report, this is what Phil Ting had done, where they actually, and I'm just going to scroll down here so you can see right on page 1 of this report is again linked to the website. Actually, I have it under legal action by state, and you'll see right here in on page 1 that the 84% of the loans actually have had at least one legal violation. See, we identified one or more irregularities in 99% of the loans. In 84% of the loans, we identified what appeared to be one or more clear violations of law. It goes on to talk about 66% had multiple legal violations. We already know from these articles, and like we talked about earlier today, that most of the independent foreclosure review, most of those foreclosures that applied for review had problems, and the banks are just saying, oh, well, we're not going to count that one. We're not going to count this one, and we're not going to give anybody any restitution. And the fact is, the people are being lost. The OCC is being bought off by the bank cartel. It's a government being completely in control of the people they're supposed to regulate, and the people need to rise up and do something about it. I did want to mention that the largest Hispanic newspaper in LA area has printed an article referring to Homeowners for Justice. They interviewed me for this. So that's also linked to the Stealing Our Homes website. So if you'd like to read it in Spanish, please just get on hofj.org and go to Stealing Our Homes. You'll see it, the title's in Spanish. Here's the Equitas report. I did want to talk about the foreclosure mills. They've been shut down in Florida. This one is Marshall Watson. They've shut them down. It's a well-known so-called foreclosure mill. These are law firms. These are attorneys that are forging these documents. I want you to really get this. The documents being forged are being forged by attorneys. Attorneys are running these firms, and they are telling their people, they are hiring people to forge documents and make this stuff up and take the house. And they're being paid very, very well to do this. So Marshall Watson is sort of like a recon trust on the West Coast. This is an East Coast foreclosure mill. They've been shut down. They've agreed to a 91-day suspension. In my book, they should have their license revoked. We need to really do what Iceland did, and that is stand up and put these banksters and everybody involved, that would be the attorneys, all the people they hired to forge these documents, and all the banksters that are paying them and are pushing this off on the public. We should charge them, criminally charge them with fraud and conspiracy to commit fraud. Here's the article about Doc X. Founder of a Florida-based mortgage servicing firm pled guilty Tuesday, this is in November, to a federal criminal charge stemming from complaints she directed employees to forge signatures on foreclosure-related documents. Now, you and I would expect that every one of those foreclosures should be rescinded, and if they're in process, they should be stopped. Chances are that isn't happening. The people, come on Florida, you guys need to step up and wherever they have filed these documents, this is LPS Document Solutions, they subcontracted DocX. Every one of these foreclosure mills is doing the same thing. So in this state, it's Recon Trust in California. They foreclosed for Bank of America. Did you know that Recon Trust is not allowed to operate in Washington or Oregon? So why are they allowed to operate in California? Let's rise up and stop these foreclosure mills. Let's make sure that everybody working in the foreclosure mills understands that they will be personally liable. We're going to go after them, whether they are just some $10 an hour person signing somebody else's name without the authority to do so, or whether they're the people in charge. We want to put all of them in prison, charge them with fines, make them subject to the felony laws. It's a felony in this state under the criminal code 115 to forge someone else's signature and cause that forgery to be recorded on someone else's property. This is a huge violation, and that's why I keep calling it a theft of our real estate. Now, one thing I did want to talk about real quickly is the SB 900. Because this is a law that is passed by our legislature, and it's for the benefit of the people facing foreclosure. And I want to read aloud. The law is actually on my website. You can just download it, look at it yourself, and print it. But you know, most people don't read through what it says. So let me just read it pieces out loud, and I've highlighted it. I will... the one that's on my website linked up there is not highlighted. I will relink the highlighted one so that you can see it. So let's take a quick look at it. On page 1, This says the bill would add mortgage servicers as defined to these provisions. So that means even if they're just a servicer, like Ocwen, Nation Star, the big ones that have risen up and bought the servicing rights from Bank of America, Chase, Citicorp. The fact of the matter is, by the way, that these servicers, they are wholly owned bank subsidiaries. So never forget, the banks are playing the subsidiary shell game. Please understand that. They create another subsidiary, they wholly own it, and then they shove it out there and they say, oh, now you're going to be an appraisal management company. And so all the appraisals, now the banksters get a fee. Or they say, oh, you're going to be field asset company. And so every time the field asset has to manage an REO, a bank-owned property that they've illegally foreclosed, then the banks get paid the fees. Who pays? The investors. They're losing money. The banks are in the middle, setting up their wholly owned subsidiaries. That is the way they operate. So the foreclosure trustees, which Recon Trust, many of these are wholly owned bank subsidiaries, but run by attorneys. The field asset managers, field asset companies that manage the REOs, those are wholly owned bank subsidiaries. Appraisal management companies. Now you've got servicers, Ocwen, Nation Star. B of A says, I don't want to do that anymore. I got an idea. I'll set up a wholly owned subsidiary and they can buy the servicing rights. The fact of the matter is, B of A is still the master servicer and is not off the hook. So don't ever get confused about that. The master servicers are the ones that sign the consent orders from the judge saying, you're going to cease and desist doing all this forgery stuff. And guess what? They didn't. They're not. They can't. Because if they actually ceased and desisted filing forged documents, they couldn't foreclose. And that's the point. So I want to back to SB 900. This bill for California is 5 years, is in operation till January 1, 2018, and it establishes additional procedures to be followed regarding a first lien loan modification application, the denial of the app, and a borrower's right to appeal the denial. So listen up, people. As we're trying to get together to figure out how we can really, in a wholesale manner, stop foreclosures and keep people in their homes, each person is having to fight individually. So here's some new law that you can maybe take advantage of. Now notice down here I have, an entity shall not record a notice of default or otherwise initiate the foreclosure process unless it is the holder of the beneficial interest under the deed of trust, the holder of the beneficial interest, it is the beneficiary, the original or substituted trustee, or the designated agent of the holder of the beneficial interest. Now, each one of those statements brings into the courtroom specific law. And this is why when we talk about forged documents and the authority, when the trustee's substitutions are forged, then they don't have this authority that's being talked about. So I'm not an attorney, but it would make total sense to me that right now, with this new law in place, owners should be able to go into court on this standing and say, look, they forged this document, they do not have this right, Index has given it to themselves. You can look at your documents and go into court on this statement. Well, this is just a summary, but it does state in the law that this is a requirement. Yes, we have to do it. The owners have to do the lawsuit. We don't have the AG, we can't get the DAs often to do this for us. However, there is some standing. This is what I'm saying. So this bill would authorize the borrower to seek an injunction and damages of certain of these provisions, treble actual damages or $50,000 in statutory damages, and if they are found to be intentional or reckless or resulted from willful misconduct. Come on, guys. What we've been hearing and what we've been talking about is the fact that this is completely willful misconduct. They are intentionally doing this. It's willful. It is misconduct. They do know what they're doing. We have proof of it with these other foreclosure mills being shut down for forgery. So I believe some attorneys and some owners, it'll probably cost something. But I think there's cases here. There's now a law that we're going to be able to use in court. I'm confident people will start to try. So I'm just putting it out there. Notice, though, that this law is applicable only to mortgages or deeds of trust secured by residential real property not exceeding 4 dwelling units that is owner occupied. So unfortunately, investors, it's not going to, if from this summary, it doesn't seem as if this will protect rentals or investment properties, but it would protect owner-occupied 1 to 4 units. And again, it's only against those foreclosure mills, if you will, that do more than 175 foreclosure sales a year. So it's going to be against the big guys, like Recon Trust, Cal Reconveyance, Quality Loan Servicing. You know, I've got the 17 listed entities. If you go to foreclosure forgery file complaints, I think it's on that webpage. I have the list of the foreclosure trustees. So I'm sure that you can find yours there. And if you need to know who your foreclosure trustee is, you can just email me. I can find out for you. So the bill would require that a special declaration, specified like a notice of default, notice of sale, deed of trust, an assignment of the deed of trust, a trustee substitution. This is where all the fraud takes place. These 3 documents, the notice of default, the assignments, and the trustee substitutions, because it's only the trustee that can file the notice of default. So they have to substitute the trustee and then file the notice of default. Often they file the NOD first, then substitute the trustee. That's voidable. That's illegal according to our laws. And so now we have a law, this bill, SB 900, that would say that these filed in any court relative to a foreclosure shall be accurate and complete and supported by competent and reliable evidence. So this is opening the door, guys. I swear, this is opening the door for us to file lawsuits that can stop the foreclosures, get notices of default rescinded, because they're saying it has to be accurate and complete. So just go into court and show that it's not, and get the judge. Now the judge doesn't have to worry about it. They can say, well, yep, that's what the law says. So now I can rule in favor of the owner. Now, I just wanted to point out, they're talking about there's more than 2 million underwater mortgages. That's absolutely true. And the fact is, it's a huge crisis. If you'll notice with this little sign I have up now again, that we're only halfway through. They're going to take all these loans unless we stop them. That is the point. I've been saying that for 3 years, and it remains to be true. So skipping on down to which page are we going to look at here? Page 11. I wanted to point out that anticipated recovery under loan modification or workout, they've now put into law that if the investor in the mortgage-backed security will actually get more proceeds by doing the loan mod with the owner than a foreclosure in which the bank gets more money. See, this is why they keep foreclosing. The bank gets paid over and over and over. But if now with the loan mod, that's a higher net proceeds, which it most of the time would be, then they're required to do that. That it must happen. And if they don't, the borrowers have the right to demand that net present value basis. And I just want to bring in here a quick mention. I spoke to an attorney who's doing class actions, and I hope to get him on the show next week. The fact is, he was involved in helping set up this net present value formula, and they have found that over 50% of the loan modifications that were denied actually violated the net present value basis. They violate the formula, and it just substantiates what I've been saying all along, and that is the banks foreclose because the banks make money foreclosing, and they don't care a hoot about you and me or the real estate market or the contractors or the destruction of the economy or anything on the planet, just their own money. And this is why we have to rise up and stop these bullyings. So to read some more, if a borrower submits a complete application for a first lien loan, while that is pending, that loan mod app is pending, that mortgagee, whoever it might be, shall not record a notice of default or notice of sale or conduct a trustee's sale until any of the following occur. Either the borrower is not eligible, the borrower does not accept the loan mod, or if the borrower accepts but defaults on the loan mod, and if the borrower's app is denied, they have at least 30 days from the denial to appeal the denial. So don't let these servicers run roughshod over you. Read the law, know the law, demand that they stop their notice of default, they stop the sale, demand your rights, demand the information that you are now allowed by law in California to require. And so it says here under item E, they shall not record a notice of default, or if one's been recorded, they can't record the notice of sale or even conduct a trustee's sale until at least 31 days after the borrower is noted in writing of the denial. But if the borrower appeals, there has to be the later of 15 days after the denial of the appeal. Doesn't say how long that appeal process is going to take. Or 14 days after a first lien loan mod is offered after appeal but declined by the borrower. And it goes on. You can read it for yourself. I just want you guys to really start looking into the law and how it's going to help you personally. And I can't answer everybody's questions. I can't, I'm sorry. That's why I'm doing the live streaming and trying to answer them here in general. Do a little research. Here's SB 900. This was passed for you. So now I just really quickly before we go want to talk about the single point of contact, what that means. And that means it's an individual or a team of personnel, each of whom has the ability and authority to perform the responsibilities described. So it's not just one person. But again, it can feel somewhat like you're going to be getting tossed around when they're different people. Theoretically, they're to have everything on the file, so whoever is talking to you in that department should be able to pick up where the other person left off. Now, here is a real big issue. If a notice of sale has been postponed for at least 10 business days, now they must provide you, the borrower, written notice of when it's going to happen. This has happened a lot. The current law says you only have to notify them the first time there's notice of sale. So they notice you the first time, then that notice of sale is postponed. And so then the borrower thinks, oh, phew, they're not selling. And then all of a sudden, somebody knocks on the door and says, get out, I bought the house. And they go, what? And that's because they were never notified of the next notice of sale. They didn't even know that it was happening and being recorded and going to happen. And so this law says, whoa, 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 stop, can't do that. And here it says no entity shall record. This is the verbiage of what I said from in the summary. This is the piece of the law. We're on page 15. That says no entity shall record or cause a notice of default to be recorded or otherwise initiate the foreclosure process unless it is the holder of the beneficial interest under the mortgage or deed of trust, the original trustee or substituted trustee, and of course legally under the deed of trust, or the designated agent of the holder of the beneficial trust. This is the standing that you can use. This is the law you can quote when you go into court, or your attorney can go into court for you and say, I'm sorry, we just did an audit and we found that blah, 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 blah. This entity has nothing to do with a notice of default, so therefore, stop it. So I'm going to be very excited to see what kinds of things can happen and what kind of new law is going to be coming out in this state. Next week, I really hope to have the Project Reconomy as a guest on one of our shows. Oregon has been working very hard and organized. They've gotten attorneys together to submit good lawsuits to get good judgments, and that's why they've actually gotten a good judgment on the MERS. And now, of course, the Supreme Court is hearing the appeal because the banksters really don't want to lose the right of MERS in Oregon. If MERS, by the way, it struck me that MERS claims to be a rabbit and a tiger. That's the point. I'm a nominee, and I'm a beneficiary. So I'm a rabbit or I'm a tiger, and I'm a tiger. And that way MERS can decide whatever the case is, I'm a rabbit now, oops, I'm a tiger now. And this is why it's so confusing to the attorneys and the judges, because they've mixed up the law. They've, like we talked about yesterday and today, they've taken tangible property and they've pulled out the essence of the value in that tangible note, and they've called it intangible. Now it's a totally different set of laws, Article 9, where this is Article 3. Don't quote me, I think that's right. And next Wednesday, Valerie's going to come back with the listing of all of the laws so that we can simplify this for everybody in the country, and we can stop this foreclosure crisis, because it is truly fraud. You know, really, I thank you for watching, and watch tomorrow. Don't forget, if you're a group, it's Update Fridays. Please let us know what's going on in your group. We'd love to have updates. We've got several people that are going to be updating what their group is doing. We've got some real movement going on, and everybody wants to know what everybody else is doing for various reasons. Number one, and I would say not only is just the plus of knowing that you're not alone. There's other people fighting, and they're fighting all over the country. And I'm going to highlight specific lawsuits. I will try to find out the status of those lawsuits, but I'm not sure I can get that information by tomorrow. But we will show the kinds of lawsuits and efforts that are going on around the country. But if you're a group of Occupy or ACE or any kind of fighting for homeowner justice, even an individual, and you've got something to share, please let me know today. We'll get you on the calendar for tomorrow, and you can share with everyone from 10 to 11 Pacific Standard Time. So this is CJ, founder of Homeowners for Justice, signing off. Thank you so much. Till tomorrow.